But first, it's time to welcome our legal voice of the week. Today, we are joined by Puneet Chaturvedi, owner SCC Advocates, joining us from our Mumbai studio. Puneet, thank you so much for joining us today. Let's just get started with our queries. We have GP Bhardwaj with a question dialing in. Hi, sir. What's your question? Hello, can you hear us?
Yeah. GP Bhardwaj this side.
Go ahead.
Namaskar to all NDTV viewers.
So what's your question? Please go ahead.
Then my question is with respect to the possession of an apartment in 109 sector in Gurgaon. The builder, he has actually taken the completion certificate from the authority, but when really we went to the site, actually there was no water, no electricity, and there is no sewage connection. Water they are providing from the borewell and through tankers. Sewage they have constructed a STP, and with respect to electricity, they have installed the generators, which will be very costly. And I don't know, the maintenance cost is very high. Means the expense itself of staying in that area will be around 30,000 rupees per month.
Okay.
And I don't know how they have got the completion certificate, and they are forcing us to sign all the documents which are, I don't know how far I understand that they are not ready to give the key until we sign the maintenance agreement, which is of their choice.
Okay, so the builder is yet to develop all the basic infrastructure inside the project. Builder claims he has a completion certificate and is asking the flat owners to sign a maintenance agreement, charging quite a high fee, even though much of the internal infrastructure is yet to come in place. What's your advice for him?
Mr. Bhardwaj's question is that he says that the OC has been obtained by the builder from the municipality, that is occupation certificate. Now, normally the completion certificate or the occupation certificate is provided by the municipality only when all the legal formalities are in place. The builder is satisfied, the municipality is satisfied that the building has all the facilities which are to be provided to the customers, like water connection, the lift is working in the proper fashion, the elevation is proper, the builder has completed the building as per the plan. Only in situation where the municipality is satisfied about these completions, then the completion certificate, the occupation certificate is provided. Now, as per Mr. Bhardwaj, that these facilities have not been provided by the builder, and there is no water connection, and the borewell water is being provided to them, and there is no facility as being propagated by the builder. In such a situation, the solution before Mr. Bhardwaj is to immediately issue a legal notice to the builder stating that within the specified time, if he is ready to provide these facilities to them, then only they will be taking the possession, or otherwise he can refuse to take the possession at the cost of the builder. Secondly, he can also initiate a criminal proceedings in the criminal courts against the builder, stating the fraudulent activity which he is indulging into. So these in such situations, and he can also write to the municipality concerned that how this occupation certificate has been provided when the water connections through the municipal water has not been provided by the builder. So in these situations, these remedies are available to Mr. Bhardwaj, which he can avail immediately.
Okay, so very important learning for our other viewers as well. If your builder is claiming to have a completion certificate or an occupation certificate, this process can't be completed unless and until the complex is entirely livable in the eyes of the local authorities, the municipalities. It should have all services and amenities important for residents to move into that locality. So you must check with your developer. If he's claiming he has an OC, check on what basis he's making that claim. We also have Usha Khanna with a question for us. Hi, how can we help you?
Thanks for taking my question. Firstly, you are doing a commendable job enlightening the owners or the builders about it.
Thank you.
And my question is that I have taken a house in Amanora Parktown, Pune. This possession was taken 3 years ago, and since then it has been rented out. Now the builder is asking for 10% extra maintenance for the rented houses, and that too retrospectively. How far, under which law, provision or ruling does this come?
Okay, so Puneet, Usha has a property in Pune. The builder has sent a new communication to her asking to charge 10% on the flat because she's given it out on rent, and he wants it to charge retrospectively. How valid is this?
Now, Usha ji, there is a provision under the Cooperative Societies Act which says that normally if the flat is being rented out and not occupied by the owner, the society is entitled to charge non-occupancy charges. But two things which differ over here in your case. Firstly, that the builders are not entitled, because if you are saying that the building has been completed and being handed over to the owners for last 3 years, then how come the society has not been formed as yet? So first and foremost, you along with your all residents can initiate the proceedings informing the registrar of the cooperative societies that why the builder is not forming the society, and you can initiate to form a cooperative society in your building. Secondly, the non-occupancy charges can never be levied retrospectively. So if, as per your question, if he is charging you for the last 3 years at the rate of 10% and all, that you can definitely litigate and dispute about in the court of law and dispute his demand in the cooperative court as well as in the criminal courts, that he cannot demand the retrospective non-occupancy charges. And the most surprising fact is that how the society has not been formed as yet.
All right, Usha, there you have it. Puneet says that very important that you and your fellow flat owners need to group together and approach the registrar of societies and form a society. It's been about 3 years since possession has been granted in your society. So high time that you form your own society, and also the builder cannot charge you non-occupancy charges retrospectively. All right, we also have Neeraj Dhaya with a question. He wrote us this email saying he needs advice on a property he booked about 1.5 years back in Greater Noida. It was a pre-launch project, so there were no approvals at that point, and the builder had claimed that 6 months later he will provide all documents and approvals. However, he has been approaching the builder several times and is yet to get any response on the clearances and approvals. He now wants to withdraw his booking and wants a refund, but he is told the company has stopped refunds and cannot process it anymore. How can he pressurize them to refund the booking amount? Puneet?
This is strange and very surprising, because normally in case that there is no construction going on or some kind of a delay in the project, the builders themselves come forward to refund, because property prices are going up each day, and refunds are a cheap cost to the builder. So normally the person who books the flat resists the refund. He says that I need the possession of the property. And in case if Mr. Dhaya is trying to get a refund and the builder is not providing the refund, then immediately he must issue a legal notice for a specified time, fixing that in such a specified time, if the money is not refunded, an X amount of interest would be levied upon the builder, and he can immediately move the consumer court demanding the performance of the contract. Secondly, he can also initiate the criminal proceedings against the builder that he has defrauded him by offering that he will be coming up with the project and he has not even initiated the project and he's taken the money. So it's a criminal breach of trust as well. So he can initiate criminal breach of trust in the court of law, in the criminal court as well as in the consumer court for non-performance of the services. And in case if he has an agreement for sale entered into with the builder, he can also move a civil court for the specific performance of the contract.
All right, so Neeraj, very clearly you can initiate criminal proceedings against your builder for non-performance of all the rights that you have in your builder by agreement. That's the only way for you to pressurize him to refund your booking amount. Another reason why the builder could be resisting is maybe shortage of funds, given that it was a pre-launch project. All right, Puneet Chaturvedi there. Thank you so much for all your expert legal inputs.